I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. Donald Trump's lawyers, Evan Corcoran and Lindsay Halligan, were spotted in federal court in Washington, D.C., apparently for a proceeding in the secret grand jury relating to the criminal investigation of Donald Trump stealing government records, including top secret records and top secret sensitive compartmented information and thousands of other government records. And what's interesting is that this proceeding was taking place in the Washington, D.C. court. We've discussed the proceedings taking place before Judge Eileen Cannon, who is the district court judge who asserted, and we've talked about here wrongfully, which we think the 11th Circuit Court of Appeals is going to find, but she's asserted jurisdiction in the motion for judicial oversight that Donald Trump filed after a magistrate judge from the Southern District of Florida, Judge Reinhart, found probable cause and issued the search warrant to be executed on Mar-A-Lago, and that search warrant was executed on August 8th. But what we can't lose sight of here is that actually the criminal investigation into Donald Trump's conduct, the criminal investigation, is being run through a grand jury taking place in Washington, D.C. And the reason that ultimately the search warrant was signed off by a magistrate judge in the Southern District of Florida is because that is who had jurisdiction over the Mar-A-Lago premises. But otherwise, actually, the criminal investigation is taking place in Washington, D.C. And you'll recall from our reporting, for example, that the subpoena that was issued to Donald Trump to return classified records and other government records after it was clear that he was still hiding records, that grand jury subpoena, which was issued in May of 2022, well, that came from the grand jury in Washington, D.C. And ultimately, it's that grand jury likely that would have the power to indict Donald Trump or to indict Trump allies like Kash Patel, or perhaps even Trump's lawyers, or people like Christina Bobb, who's signing as the custodian of records on these false declarations that have been submitted to the Department of Justice in response to the grand jury subpoena. But all of that actually it's taking place out of Washington, D.C. So what are the issues that could have been discussed today? Well, one of the things we also know is that a few weeks ago, Kash Patel, one of Trump's closest allies and a former top advisor when Trump was in office, Kash Patel had actually been questioned before the grand jury. He invoked the Fifth Amendment when asked all these questions about the documents that were stolen at Mar-a-Lago. And Kash Patel was an individual who Trump designated to deal with the National Archives after his administration. And Kash Patel has self-identified himself to right-wing media like Breitbart as someone who had knowledge and actually saw, he claims, Donald Trump declassify all of these records relating to Russia and other national secrets. He said that I was there and I saw that be declassified. He claims that that was to help out our country, obviously gaslighting and projecting, but that's what he told Breitbart in an interview back in May. And so Kash Patel was called to speak in front of the grand jury recently, and he pled the Fifth. And so one of the issues is the Department of Justice is trying to find ways to compel him to testify, and that could be done by giving him an immunity grant or a cooperation agreement. I did a video about other ways they could compel him to try to testify, but that is one of the issues that are currently existing. Other issues that are existing are the Department of Justice is currently looking for other documents that Donald Trump likely stole. Documents that he may be hiding in Bedminster, documents he may be hiding in Trump Tower, other documents that they are pursuing. And it is possible that Donald Trump is claiming some sort of privilege related to those records and is not turning over those records. So the Department of Justice is asking the judge who oversees the grand jury proceedings to compel those records. One of the things we also know, though, in addition to Kash Patel, the Department of Justice has been calling numerous other individuals who worked with Trump during the administration and after the administration. A number of lawyers, for example. I think there was a lawyer by the name of Cannon who was a lawyer who Trump tried to get to lie to the Department of Justice that all of the records were turned over, and that lawyer refused to tell the Department of Justice that these records were all turned over, or that Trump didn't have all of the records, because he knew that to be a lie. So one of the things that the Department of Justice is perhaps asking the judge overseeing the grand jury to do is to compel individuals to testify, because we've seen in other grand juries regarding other matters that Donald Trump has asserted executive privilege to try to block testimony. I mean, just yesterday, and we were reporting on it today, we learned that in addition to Mark Short, who's already fully testified on issues, including issues where Trump tried to claim executive privilege. And Mark Short was former Vice President Pence's former chief of staff, and Greg Jacob, who was former Vice President Pence's former general counsel. They testified in front of the other grand jury, right? There's different grand juries taking place in Washington, D.C. So there's the Mar-A-Lago search warrant grand jury. And then you have the grand jury that's engaged in the criminal investigation related to election interference on January 6th. And in that other grand jury, Trump asserted executive privilege and tried to stop Greg Jacob and Mark Short, Pence's top aides, from testifying there. The Department of Justice had to go in. They had to get a motion to compel. And the judge there, it's Chief Judge Beryl Howell, she held that executive privilege did not apply there and compelled those individuals, Mark Short, to testify and Greg Jacob to testify. And then we've learned that Pat Cipollone and Patrick Philbin, Trump's top White House lawyer, former top White House lawyer, and Patrick Philbin, the top deputy to Pat Cipollone, they also couldn't testify fully to the Department of Justice because Trump was asserting executive privilege there. So we learned that the Department of Justice is compelling that testimony as well. We're waiting on a ruling there from Judge Beryl Howell as well. But that is pending. And so here, we could assume Trump is doing the same games, which ultimately it's actually in front of the same judge. So the chief judge of the district court in Washington, D.C., Chief Judge Beryl Howell, is pretty much assigned to resolve disputes that take place in these grand jury proceedings. So she resolves disputes in the January 6th, insurrection-related grand jury, and here in the Donald Trump stealing top secret records and other government records criminal grand jury. And so one of the things these lawyers, Evan Corcoran and Lindsay Halligan, who represent Trump, could be asking for is also they could be asserting executive privilege on Trump's behalf, an attorney-client privilege on Trump's behalf, to try to stop the Department of Justice from questioning lawyers, from trying to question staff, from trying to question people who worked at the White House. And their objections have mostly been frivolous, and I would assume that Chief Judge Beryl Howell will overrule them. But we're yet to really know what specific asks are going to be made. Now, one of the things, too, about Evan Corcoran being in there, which I find interesting, is that in many ways, Evan Corcoran himself could potentially be he's definitely a witness in connection with Donald Trump stealing records and with the obstruction by Donald Trump. And, I think, in my opinion, he has potential criminal exposure. Heck, he was one of the lawyers in response to the grand jury subpoena that was issued by this Washington, D.C. criminal grand jury in May. He was one of the lawyers who worked with Christina Bobb, a Trump lawyer who identifies herself as a custodian of records now. But regardless, they signed a declaration to the Department of Justice saying all of the records have been turned over and that there are no more records after a diligent search that they conducted, which turned out to be completely false. They provided a false statement. Now, the statement actually said, based upon what has been told to me, a diligent search was conducted. But obviously a diligent search wasn't conducted because on August 8th, when the Department of Justice executed the search warrant, they found the records right away. They found 11,000 plus documents and about 100 top secret classified records, sensitive compartmented information, the highest level of classification that exists. And so clearly things are moving along expeditiously now before this grand jury. It is important that we're seeing action in Washington, D.C., and it's important to remind you that even though we've seen things, mostly so far, we've been talking about what's transpired in the Southern District of Florida, where the search warrant issued, where Trump filed that motion for judicial oversight, and where Judge Eileen Cannon has made those horrible rulings, which are currently being appealed to the 11th Circuit Court of Appeals. And I've told everybody who watches this, I'm like 99% confident I can say that Judge Eileen Cannon is going to be overruled sometime late November or December. It depends on when oral argument is. So shortly after oral argument, final briefing in the appeal is November 17th in the Department of Justice's appeal there. But I've predicted that since the 11th Circuit has already ruled Judge Eileen Cannon did not have jurisdiction relating to the 100 classified records, which they were correct in making that finding. It was an obvious finding, and ordering those documents be returned to the Department of Justice. It's the same analysis that applies to all of the other documents, which are still part of the process that Judge Eileen Cannon erroneously set in motion. So Judge Eileen Cannon's going to be removed from this case. But in any event, we've talked about the Southern District of Florida. We've talked about the Eastern District of New York, because that's where the special master, Judge Raymond Dearie, is overseeing those proceedings. But we haven't talked about D.C. If there were to be an indictment, which I think there will be, if there were to be an indictment, though, that will come out of the Washington, D.C. Grand jury, and it will be the jurisdiction where the case will ultimately take place is in Washington, D.C. It's not going to take place in Florida. It's not taking place in New York. It's going to be a D.C. case because this involves the theft of government records. And all of Trump's arguments have just been completely wrong. And, when he's tried to, before Judge Raymond Dearie, he's claimed certain records are his personal records. And he also claims executive privilege. And he claims that under the Presidential Records Act, he can just do whatever the heck he wants. He doesn't. There's a process. You can steal government records. You certainly can steal top secret sensitive compartmented information. And you can't lie to the Department of Justice when they ask for the documents back that you stole. It's just that simple. And I said on the MeidasTouch podcast, I said on Legal AF, and I'll say it here again. I think there will be an indictment in connection with the theft of these records. I absolutely do. I think that there is, and in terms of the case that's the strongest, this is a home run slam dunk of a case. All of the elements are there. And it's just kind of dotting I's, crossing T's at this point. But we will keep you posted here. It definitely is unprecedented that you have a president steal records like this, despite all the disinformation that Trump spews. This has never happened before, where we literally have a president stealing records on nuclear secrets and stealing records about missile programs, doing whatever the hell he's doing with it in his transactional, corrupt way. And the Department of Justice needs to be robust here. They need to be law and order here. And look, I think Merrick Garland has been law and order. It takes time to build these cases. But we will keep you posted on the MeidasTouch Network. Hit the subscribe button right now. We're on our way to 1 million subscribers with your support. And in addition to subscribing, it would be really helpful if you checked out patreon.com/MeidasTouch. We are not funded by any outside investors at all. So we rely on your generosity to grow this independent media platform. So check us out at patreon.com/MeidasTouch. Join one of the membership packages there if you can. It will help grow this platform. You get a lot of great exclusive content, Q&As, other perks. There's some great ones, like on one tier, you can become a producer of the MeidasTouch podcast and your name will appear. But you always ask what you can do. If you can, no pressure, but if you can, it goes a long way and it helps. Check us out there at patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.